So good afternoon, and thank you for joining us for the webinar, The Keys to Contract Negotiation and Review. My name is Ken Hyman, and I'm an account manager with Meriwether & Williams Insurance Services, a Hub International company. Please be aware that we will be recording this webinar so that we can make it available to everyone at a later date. Before I begin, I would like to go over a few housekeeping items. If you are experiencing any technical or audio issues, please reach out to me via chat box, which is located at the bottom of your screen. If you have any questions anytime throughout the presentation, please type your question in the chat. Also, a brief survey will be sent out shortly after the webinar concludes to gain your input and feedback. Please be on the lookout for it, as we really appreciate you completing the survey. And let me call up more. So if you have a question, use the raise hand feature to be acknowledged and to ask your question. The camera and microphone, the camera must be on during the class period or webinar. Feel free to participate in the webinar, ask questions, and we will check the chat and raise your hand feature. And then also, please be sure to fill out our survey. You can reach it through this QR code, and I'll be putting up this information again at the conclusion of the webinar. And here we have contact information, which I will again be sharing at the conclusion of our webinar. Bear with me for a second here. One moment, please. Okay. And I also want to mention that a copy of today's PowerPoint presentation and a link to the recording will be provided after the workshop. Once we receive we need to receive your completed survey as well in order to facilitate that. Just so you know, Meriwether & Williams Insurance Services, a Hub International company, specializes in technical assistance programs, providing services to small and emerging contractors. Some of those services are educational training, bonding support, and contract-based finance support. This webinar will focus on contract negotiation and review, legal protection, scope management, payment terms, timelines, deliverables, risk management, dispute resolution, and other contract-related topics. So having said that, please allow me to introduce our presenter, Kurt Chamberlain, Executive Vice President, National Construction Practice Leader with Hub International. Kirk leads Hub's national construction practice and has been in the industry for more than 35 years, working in a variety of different roles, including as broker, underwriter, risk consultant, and risk manager for a large national PM firm. He also leads Hub's internal construction training initiatives and helps support external training activities as well. Hub's National Construction Specialty Team comprises more than 800 professionals based across more than 125 offices. They represent around 10,500 general contractors and more than 24,000 subs and trade contractors across the U.S. and Canada. So with that, let me call up the presentation. Hopefully you can all see that, and let us continue with the webinar. Take it away, Kurt.
Thank you, Ken. Appreciate it. Good afternoon, everybody. We will try to make this as not dry as possible. We are talking primarily about insurance here, which is not really everybody's favorite topic, but I appreciate you hanging in with us while we go through this material today. As Ken mentioned, we are brokers. We do represent a lot of contractors, but we also have a lot of public and private developer clients, so municipalities, owners and developers. So from the perspective of this topic, this contractual risk transfer, we find ourselves on both sides of the negotiating table on any given transaction. So what I'm going to try to do is give you not only a perspective on contract risk transfer and risk management from the contractor's perspective, but what are the owners thinking? Why are they asking for some of the things that they're asking of you? So that when they do ask, you guys have some visibility and some insight into where those questions are coming from and why it's important for them. So with that, Ken, can we go ahead and jump in, and I'm going to take myself off video here. So here are the high level objectives. As Ken mentioned, there's a whole bunch of different elements to contract risk transfer, contract risk management. We're really going to focus today primarily in and around the issues of indemnification and on insurance. So again, there's a lot of other things that we probably won't touch on just given time. So focused really intensely here on the insurance piece and the indemnification piece. Ideally, what we want to do is get through. Hopefully, by the end of this, you'll feel a little bit more comfortable with these topics. Most of you, or I'm sure all of you, probably have either insurance brokers or agents that you work with. This is part of their primary responsibility. Certainly, that's our primary responsibility when we work with clients, is to help them work through these issues, understand what they're signing, understand why they're being asked what they're being asked, and how best to respond in a cost-effective way. So we're going to go right down this list here, kind of one by one. We can go to that next slide. So again, this is the only humor in the entire presentation, I'm afraid. So hopefully this is enjoy it while you got it. This just kind of reinforces a point that we talk about a lot on the legal side and also on the contract review side. And the only difference between those two sentences is a comma, but obviously that comma makes a bit of a difference in the intent. So this is what we run into all the time in contract review. Things like punctuation marks, whether it's singular or plural, little changes to words and letters and punctuation marks actually make a difference in the contract. So we got to really pay close attention to those things. Make sure that we understand what we're being asked to do, what kind of risks we're being asked to take, what kind of risks our clients are being asked to take, and make sure everybody's on board with that before we sign off on these things. We can go to that next slide, please. So anyway, we touched on this. So here's the rough agenda. I'm going to start with certificates of insurance, because that's what probably most of you are most familiar with on the document side. Other than the contracts, probably the most common thing you see float across your desk between your broker and your clients are these certificates of insurance. I want to spend a couple minutes talking about why we use them, what they are, what they say, what they don't say, and what their intent is. And then we'll go down through a little more on the contract review side. We'll talk a little about indemnity agreements and additional insured status, which is one of the key topics for today. And then we'll wrap up with just a few, frequently asked questions, some tips and tricks that we employ, and then we'll open it up for questions. But I would ask you, as Ken mentioned, if you've got questions during the presentation, please go ahead and throw them in the chat. I think we've got one already. And Ken will stop me and we'll address those as we go. So Ken, is there anything in there we need to address now? I saw something pop.
Let me take a look. No, we're good.
Okay. Next slide, please. So first, we'll start off with certificates of insurance. We can go to that next slide. So why do we do contract review? How do we start? Some of the tips and tricks, and what other resources do you have available to you? So the main reason we do contract review, and this is our 50,000-foot flyover, is you're going to be signing contracts with general contractors and owners, so upstream, that are going to bind you legally to certain risks. So we do that contract review to make sure, A, that the risks that you're being asked to take are reasonable and are within your scope, right? Things that you have control over, and B, that they're equitable, right? We don't want to find you or allow you to find yourself in a position where you're being contractually asked to take a risk that you really can't take. Either you can't afford to take, you're not in a position to take, you don't have the resources to take. Not only is that unfair to you, but it's also a bad idea for the owner and for the project, because all that does is create a weak link in the chain. So we really pay attention not only to making sure that everybody understands what's being agreed and signed to, but also that it's fair and equitable, right? What you're being asked to do and the risks you're being asked to take are reasonable. That flows both directions. So some of you many of you will be sort of receiving these contracts and being asked to take these risks. So you'll be on the sort of the the subcontractor side of this conversation and having a lot of risk being pushed down to you or attempting to push down to you. But some of you will also be acting either as primes or sometimes GCs, where you're going to have subcontractors beneath you as well. So the same process and the same theory applies on both sides. On any given day, you might be asking to take certain risk and give up certain rights in the contract. On the same day, you may be asking the same thing of a subcontractor. So the same ground rules apply, whether you're working upstream to an owner or to a GC, or whether you're the GC or you're the prime and you're working down to your subs. So how do we start? Step one for us, and I think obviously for you, is making sure that we all understand the scope of the project. What are you being asked to do? How are you being asked to do it? What's the time frame? What's the budget parameters? All of those things are part of the risk review that we do. We also want to make sure that you and your team understand what tools and resources you have available to you. So your broker, your agent should be your first resource and line of defense if you get stuck or have a question about some contractual issue you're being asked to agree to and you're not sure about. We're available at Hub. Obviously, Meriwether and Williams is part of Hub now. We're thrilled about that. So we collectively also have a lot of experience and resources that we can tap on your behalf. So if you get stuck, if you can't get the right answer or a good answer out of your local agent or broker, give us a call and we're happy to help. Tips and tricks, we'll cover some of these a little later, but there's certain things that we pay particular attention to in the contract review process. One of those, and you'll hear a lot about this, is this notion of additional insured and the additional insured language that we use. And the language matters. The form of it, the actual verbiage in that additional insured endorsement that we use makes a big difference. We also want to pay very close attention to what state you're operating in. Assuming all of you are operating in the US, as most of you know, every state has their own framework and their own rules around things like statutes of repose and your responsibilities as a contractor to your owner. So there are separate set of rules, obviously, that apply to federal work, and most of you who do federal work are probably painfully familiar with that too. So, right after we understand make sure we understand the project and the risk, we also want to make sure, where are you performing this work? What is the jurisdiction under which we're all operating? Those two items will then kind of drive us in a direction as how we approach this from a risk transfer and a risk management perspective. As part of that jurisdictional issue, we also need to understand, what sort of requirements you're going to have after completion. So that would be the construction defect or the completed operations cover. In most states, well, I should say in all states, there are statutes that hold the contractor who performed the work responsible for as long as 12 years in some states after completion, if there's any kind of construction defect. That's basically why you buy insurance, right? That's the main reason. That's the main purpose of the insurance, is to make sure that you've got financial resources and your owners can be comforted that they've got financial access if there's a problem 4, 5, 6, 7, 8 years from now. And then resources, we'll touch on that in a little more detail as we go forward. Let me go to that next slide, please. So first off, we got to figure out, in any conversation, as I said, on one day you might be negotiating with a GC to try to push back some risks they're asking for you to take. On the next day or maybe that afternoon, you're having the same conversation with one of your subs. So the first thing we do is, on any given contract, we need to understand who are the counterparties, who are the two parties to that contract, who do we represent, or in other words, who are you in that contract? Are you the sub or the GC? Are you the prime or the sub? Because each party has a slightly, you all have the same basic interest, which is to get the project done. But in the contract negotiation process, each of you have different interests. So we need to start from the framework of understanding who it is that who are we helping, or who are we representing? And then we take it off from there. So again, all of the stakeholders you'll see here, the project owners, the municipalities, GCs, subs, all these other vendors and suppliers and partners are all potentially part of the conversation in this negotiation, this contract review and contract negotiation. So we need to understand who all the stakeholders are and what interest do they have in this contract. Are they financing it? Are they another sub doing work? Are they the owner who owns it and are going to operate it? I mentioned the very last thing, the neighbors. We see a lot of that too, where you're going to have to be doing some infrastructure that digging a hole next to a building, an apartment building, and those neighbors in that apartment building have a stake in that project because you're digging a hole right next to them. So there will very likely be contractual liabilities and responsibilities that we owe that neighbor too. So we got to make sure that we understand every stakeholder in the project. Next slide, please. So there is a difference, and I know you've had some prior presenters that have talked in a little more detail on the legal side of contract review. But there's definitely a difference depending on who your client is. Who are you negotiating with? If you're a sub going to a GC and you're doing public work, you know, a federal highway job or, you know, federally funded, state funded, some infrastructure, what you'll find in general is the insurance requirements and the indemnity provisions are going to be pretty fixed. They're going to be baked into the contract documents, and there's not going to be much scope for you or us to help you negotiate around those. You kind of got to meet them. Every once in a while, we find some insurance requirements in some state or federal contract where either they haven't updated it or perhaps under the circumstances, it's a little unreasonable. And we occasionally can get them to move and negotiate or show some flexibility, but we don't count on that. So we just assume that whatever the insurance requirements are that are in the bid documents are going to be the ones you have to meet with very little, if any, negotiation. And then most of that type of work, not all of it, but most of it typically requires surety bonding or you know, payment performance bonding as well. On the private side, and I'm sure many of you do private work as well as public work, I'm sure all of you have discovered on your own, typically you got more flexibility to negotiate. You know, private owner, it's their money. Oftentimes there's a bank involved and the bank will have some requirements, but sometimes even the bank's negotiable. So it helps us to understand, and it's relevant for us to understand whether you're dealing with a public owner or a private owner, because that will tell us how hard can we push back on some of the requirements. And then typically, not always, we don't always see surety bonding. In fact, we typically don't see a lot of bonding requirements on private work. Sometimes yes, but oftentimes no. Next slide, please.
Okay, and Kirk, sorry to interrupt, but if anyone has any questions, please place them in the chat. I was advised that someone raised their hand, but I don't have access to that. So again, if you have any questions, please place them in the chat, and I'm checking just about every slide. Thank you.
Okay, so as I mentioned, I'm sure all of you work with brokers or agents, your local broker, your local agent. That should be your first line of defense for support with these issues. If they're experienced with construction, I assume everybody on here is, you know, contractor in the construction space somehow. If you're not working with a broker or an agent that understands construction, I might strongly suggest finding one that is, because they can be an enormous help if they know what they're doing. And also, you know, it saves you trouble of having to basically learn and become an expert yourself if you've got a resource to lean on. So again, if your local agent can't help you, a broker, you pick up the phone and we're happy to help on our side. So when we do the contract reviews, you know, there's several things that, you know, obviously there's several reasons why you have to do it. Number one is you have to do it in order to win the work. So you've been awarded a job, here's the contract. In order to start work, you've got to meet these requirements. So, you know, we want to get involved and help because number one is we want to help you get through this process as soon as possible, so you can get to work. Number two, we want to make sure you're compliant with the insurance requirements, because if you're not, it's either going to delay the start or you may not get paid. And, you know, GCs and owners are, as you know, notorious for holding payments when they have, you know, document deficiencies. And the most common one, frankly, is on pay-ups, is deficient certificates of insurance or deficient insurance. So we want to try to avoid that whenever possible. We want to make sure you get paid when you need to get paid. And then, you know, on your side, our main job is to protect you. Your broker and agent's job is to protect your interest. So yes, they want to get it done quickly. Yes, they want to satisfy the owner, but we also have a duty to you as our client to make sure that, you know, A, that you're not signing up for something that is completely unreasonable from a risk perspective, and B, the stuff that you're signing up for, you can actually meet those obligations. If you can't, our first job is to point that out and make sure you're aware of it. You know, we can't tell you not to sign a contract, but, you know, I'll tell you honestly, I've had a number of conversations over the years with contractors, clients of ours, who have been asked to sign really aggressive, really overreaching insurance and indemnity agreements for relatively small projects. And, you know, sometimes the right answer is, you know, maybe you walk away, right? If it's an unreasonable request, if the risk isn't worth the reward, sometimes that's the right answer. but that's part of your broker support role, is to help you guys come to that decision and make a good business decision for yourselves. Next slide, please.
Kirk, we do have a question,
Sure.
and the attendee asks, if we are not happy with our broker's responsiveness, how can we find a new one?
I did not plant that question. Yeah, look, if you're not happy, please reach out to the Meriwether Williams team. I mean, that part of the reason that we partnered with them and they've now become part of Hub is that, they've got relationships with contractors just like you across the country. And part of our job is to make sure that if you're not getting what you need from your local broker, we will make sure you get what you need from our team. So reach out through your Meriwether Williams contacts and we will figure out a way to get you supported, however you need to be supported.
Okay, great. Thanks, Kirk. And also, if you are unable to put your question in chat, you may put it in the Q&A feature, and I will get that and pass it along to Kirk. Thank you.
Sure thing. Okay, so certificates of insurance. Again, this is the document that most of you are probably somewhat familiar with. I'm sure you've seen it sitting on your desk going in one direction or the other. Let's talk a little bit about what it is. A certificate of insurance is basically just a shorthand summary of the insurances that you've agreed to provide. So again, this is assuming you're the sub or you're going upstream to an owner or to a GC, right? So the certificate is the insurances that you've agreed in your contract to provide that upstream partner, owner or GC, by way of the contract. And it should match up with the indemnity as well. It'll list all of the relevant information that they're going to want to know to make sure that you're complying with their requirements. It'll have, their name and addresses, or your name and address is the name insured. It'll list your broker's name, the carriers that are providing coverage, policy numbers, all this other stuff will all be on that cert. In addition, there are oftentimes some special endorsements if they're required in the contract. Oftentimes we'll also attach those endorsements to the cert as well. So this is a compliance step. This is to make sure that the owner or the GC that you agreed to provide insurance to is comfortable and satisfied that you are providing that insurance per the contract docs. So what is it? What is a certificate not? It is not a legally enforceable document, right? It's not a policy. It's not an insurance policy. It's not a contract. It's just a shorthand summary of what it is you agreed to provide them. So I only mention that because we run into situations where let's say we represent an owner and a sub gave them a cert saying they've got this insurance, and then they go to file a claim and they find out the sub doesn't have the insurance, and they just made up the cert. Well, the owner's like, well, we're just going to take this cert into court and try to enforce it. Good luck with that. The certificate is not a policy. It's not a legally binding document. It's just shorthand for what's being provided. Again, it's not a complete schedule of the policies either. It doesn't include the terms and conditions and exclusions, endorsements, all the stuff that goes into a policy. It's just shorthand. It is also not a guarantee of future insurance. So if you are, let's say, doing a multi-year project, and I assume many of you have participated in projects like that, that certificate typically is provided every year. It's an annual thing because next year you're going to have to renew your insurance program, and the owner or the holder of that certificate is going to make sure that you actually did indeed renew your program. And all of those provisions that you agreed to in the first year are still present again in the second year. So next slide, please.
Before we go on, sorry, Kurt.
Yeah,
we've got a couple more questions here.
Sure.
One of our attendees says, I am a building inspector, but I do bid projects. I am unfamiliar with the role of a broker. Can you elaborate briefly on your role in supporting a contractor / subcontractor?
Absolutely. So a broker, we use the term broker or agent, insurance broker, insurance agent, kind of interchangeable. It's not legally the same thing, but it's essentially the same thing. So what our job is we work with contractors, we work with owners, we work with inspection companies, anybody who has a need to, in the construction realm, has a need to provide insurance or buy insurance, either to protect themselves or to be compliant with a contract document. So our job is to sit down with that client, right? The contractor, the sub, the consultant, whatever they do, figure out what they do, what their exposures are. And this is a whole process we go through with them. make sure that we understand what their workflow looks like, what their scope of work looks like, who they work for, where they work, how much do they do every year, employees, vehicles, everything that represents risk to them. Come back to them with a proposal and saying, look, here's how we suggest you address these risks. Here's what and normally what we do that as a form of options. So here's what you could buy. Here's the minimum you're going to have to buy in order to be compliant with your contract requirements or your lending docs or whatever the case may be. So our job basically is to help them work through that whole process. And then once they make a decision and we bind coverage, then we manage that whole portfolio of insurance programs for them.
Okay, great. Just a couple more questions and then we'll
Sure.
move on. Someone says, sometimes I'm asked to provide two different COIs, one for our GC and a different one for an OCIP. Why?
Yeah. So great question. I didn't put OCIPs in here. So OCIP is an owner-controlled insurance program. I imagine some or maybe many of you are familiar with those. You've either been enrolled in one or perhaps you've even sponsored them yourselves. OCIP, an OCIP or a CCIP, they're really the same thing. The only difference is the O is the owner and the C is the contractor. They're basically what we call controlled insurance programs. That's what the CIP stands for. The concept is pretty straightforward. And the idea is, in the traditional sense, when we do, let's say we're going to build a $100 million highway and we're going to have a GC and we're going to have 20 or 30 subs working on that project with us. The owner would say, okay, I need, 50 million of liability and I need work comp and I need all these insurance requirements met to satisfy me and my lenders or me and the government if it's a public job. So the general contractor's job then is to make sure that his insurance and his subcontractors' insurances are compliant. So there's two ways you can do that. One is the GC can simply, in the bid documents, tell all the subs what do they got to provide, right? Here's how much liability you're going to have, here's how much work comp, et cetera. I'm sure all of you have seen that. An alternative to that is the GC tells the subs, look, we are going to buy insurance. Either we, the GC, excuse me, or we, the owner, are going to buy insurance for liability, work comp sometimes, and also umbrella for everybody on the job. Because we can buy it cheaper in bulk, if you will, for everybody than each of you can provide your own insurances. That's called a wrap-up, or sometimes an OCIP. It's the same thing. So it's really just a different way of buying insurance to satisfy an owner's requirements. The reason we do it is usually it's cheaper. Well, it's almost always cheaper for the owner to do that than relying on every sub to bring their own insurance, because usually an owner, big project, they can usually buy it cheaper at scale, if you will, than a lot of the subs can do individually. Sometimes the owner does it because they're concerned that the subcontractors are not going to be able to meet their insurance requirements. If an owner comes to a, flat work contractor, concrete guy and says, if you want to work for me, I need $100 million of liability from you. Most of our flat work contractors don't carry anything like that by way of limit. So they can't meet that requirement, but the owner still needs the insurance. So here's a way for the owner to obtain the limits that they need without putting that burden on the contractor, on the subcontractor. They do it themselves. And so it's done all the time. There's also some cost benefit, as I mentioned. Usually it's cheaper, not always, but typically it is. And the other big advantage, which is probably relevant here, is for a lot of GCs and a lot of owners, they have a financial and perhaps even a social interest, but really it's more financial, honestly, to broaden their subcontractor pool as much as they can, right? To create competition with the subs. So one way to do that is to remove the burden or remove the responsibility of the subs to meet those insurance requirements. So for some smaller subs that may not do big, public work or big projects like that every day, they don't carry big limits of insurance because they can't afford to. So this allows those smaller subs in many cases to participate on these big jobs without necessarily having to meet those big insurance requirements. So they're still protected, the owner's still protected, but the burden is not on them to go out and figure out a way to buy that big limit of insurance to meet that contract requirement. So that's an OCIP.
Great. One more question. There's still a couple more, but we'll come back to them.
Sure.
Do we reach out to you before we bid on a project, or only when the surety bond is required?
Yeah, so this whole conversation is separate and distinct from surety. So we're not really touching on that just because we're, in interest of time today. But when you're putting out a bid bond, I assume that's what you're talking about. At the point at which you're putting the bid bond out, that so usually means what's coming, right? You've seen the project documents, you're intending to bid on it because you've reviewed them. So that's a really good time to tee up your broker or your agent and say, hey, look, I'm bidding this job. Here's what the contract's going to look like. We haven't won it yet, but if we do, we want to be ready to go, right? So that's a really good sort of trigger point to engage your broker or your agent in this process. Say, hey, look, help me go through this contract. Make sure that if I win this thing, that I can meet these requirements. So it's unrelated to the bid bond process, but that time, that trigger point is a really good time to have the conversation.
Okay, great. Let's move on here.
Okay, so certificates of insurance, so what are they for, right? Again, they're shorthand. It's basically just shorthand for what it is that you're providing or agreeing to provide, and you've agreed to provide in the contract. There are limitations. Again, the certificate is not the policy, so it's just a summary of the policy. So there's going to be a lot of things that the cert's not going to address or talk about, that we also want to make sure, though, that if you're signing a contract, and this gets a little deep into the weeds on the contract stuff, but sometimes we'll see contract requirements requiring very specific types of endorsements. We see this a lot in federal work, very specific types of endorsements on the general liability and the work comp. So that's not necessarily something that's going to show up on the certificate of insurance, but it's still a requirement that you as the contractor are going to have to meet. So again, that's why we do the digging with the contract to make sure that contract, the stuff that they're asking you to do, you can do, that you can meet those requirements. And again, just reiterate it a couple times, so do it again, is that certificate of insurance is not the policy. So, if as an example, additional insured status, which we'll come back to, additional insured is this mechanism that the insurance carriers use to allow your owner, your customer, whoever you're downstream from, to benefit from your insurance. That's one of the reasons you buy the insurance, right? One reason is to protect yourself, but another reason is to protect your upstream owner client and be compliant with their requirements. So the additional insured endorsement is the tool that the general liability policy uses in order to enable that other party, the owner or the GC, to benefit from your insurance. And basically, you're then compliant with them. One big important point is, even if you are asked to provide make them additionally insured, which again, probably most of you are familiar with this term, step one is to make sure that the policy allows that. And then we make sure that it's in the policy, in your policy, and we make sure it's in your certificate to make sure it's clear that we're doing it. But we also have to make sure that in the contract itself, the contract specifically says you're going to be required to do this in a written contract. And the written part's critical, because what can happen is, if we go through all the right steps, we add them as additional insured, we have the right endorsement language, all that good stuff, but somehow or another in the contract itself, it doesn't specifically say you got to have a written contract to evidence this, then that additional insured status is useless. It's not operant. It does not work. So this is kind of a broader theme, but the contract and the indemnity provisions in the contract, which we'll touch on in a minute, and the insurance all have to work hand in glove. So even if the insurance says we're doing one thing, if the contract doesn't require it, then the insurance carrier can say, hey, look, I know it's in the policy, but your contract doesn't call for it, so we're not going to do it. And that's an out for the carrier. So we got to make sure the contract and the insurance are work hand in glove. If they don't, we're going to have a problem. And that's why we pay really close attention to this, and why your agent broker needs to be familiar enough with these contracts to be able to help you work through these issues. Next slide, please.
One quick question before we move on.
Sure.
Someone is asking, so if we have our own insurance, do we get reimbursed for it?
Typically, yes. So, that's all becomes part of the negotiation, your contract with your upstream owner, your partner, your customer. In almost all situations, the only exception being a wrap-up, which we talked about earlier. What most contractors do is once they understand what the contract requirements are, and they have a chat with the broker and make sure they're compliant, then they got to figure out a way to price that insurance cost into the contract. Usually it's in your general conditions. I've seen it, separately line itemed out, but typically it's just thrown into the general conditions in most cases. But yeah, absolutely. Most contractors that we work with, not only do they charge for the insurance, but many of them will actually gross that up a little bit. Not that they're trying to make a profit on it, but they're trying to cover their own overhead too. So they might gross up whatever the actual insurance cost is that they have to pay to the carriers. They might actually gross that up a little bit, and then pass that back through to the owner. And that's not uncommon at all. Just as a side note, that wrap-up model that I mentioned to you, one reason why wrap-ups are so popular, especially with general contractors, is that for the big GCs, and these are the big, ENR 400 types, all of them, or virtually all of them, have rolling wrap-ups. And the one reason they push those hard is because it's a profit center for them. So they mark up all of their insurances, just like many of you might, but they mark it up pretty aggressively. So, in some cases, the profitability around these wrap-up programs for the big GCs can add, 40, 50 basis points of profit to their bottom line. And if you're a GC working on a 3 or 4% fee, that's real money.
Okay, great. Let me move on here.
Okay, so again, in most contracts you're going to be asked to sign, general liability and the excess of the umbrellas is the kind of principal focus, but there's a bunch of other insurance you're going to be required to evidence and provide, or evidence that you've got to an owner. GL, we talked about. There's also auto liability, umbrella liability, workers' comp. There may be property coverages if you're providing, let's say, builder's risk or insulation floaters. If you've got property you're responsible for, you might be asked to evidence you have insurance for that. Oftentimes, not always, we're seeing a lot more requirements for professional liability, or E&O, if you will, even on subs that aren't doing design build, because there's risk there to the owner, and they want to make sure you've got coverage in case we have a problem. Cyber is another very rapidly growing requirement. We're seeing it almost all the time now, especially with federal work and some state projects. And cyber is a real problem. I won't ask because people don't typically like to talk about this, but I would venture to say that, if we represent 35,000 contractors across the US, I would say half of them have had a cyber event in the last couple of years. Either they got hacked, or more often, they got it's called phish, right? They got spoofed. Somebody got into their system, sent an email, and somebody wound up paying the wrong person, or paying some 14-year-old in the Ukraine, because they hacked into their email. That happened to a very large client of mine, 10-figure, if you can imagine, $10+ million was sent to the wrong place because somebody got in their email system and sent an email. It looked like it came from one of their clients, their owners, saying, hey, they're not one of their vendors, saying, hey, pay us. Instead, we told you to pay us to this account. We changed it, pay us to this account instead. And lo and behold, that money went out and they never saw it again. It's a real risk. And for those of you on the design, the engineering side, if you're using CAD/CAM, if you're using Bluebeam to share files, all that sort of stuff, every one of those technology tools is another, frankly, another link in the cyber risk chain that we got to make sure we take care of and you take care of. So, next slide, please. So on that certificate of insurance, there's a bunch of different boxes, and each box has a purpose and a meaning. So two of the main boxes you'll see is the so-called description of operations, DO box, we call it. And what that does is that's kind of a free form area where we can list all sorts of stuff that the owner, again, you're complying with your contractual requirements. The owner is going to want you to note specifically so that it's clear what the project is we're insuring. And that could be a line, it could be the entire thing could be filled. It really depends on what the contract requirements are for that particular owner. And then on the right-hand side is the certificate holder. The certificate holder is typically going to be your customer, your owner, right? If you're working for a GC, it'll be the GC. If you're working for an owner as a prime, it'll be the owner. In many cases, you might be asked to issue certs. Some cases, you might be asked to issue certs to the owner where you don't have a contract with the owner, right? Your contract's with the GC, but they're going to require you to do that anyway. So the certificate holder is the person with whom you're providing the insurance to. Okay, next step, please.
Kirk, quick question here from someone. Sure. This person wants to know, what is an acceptable markup / gross to pass on to the owner? What, in terms of percentage?
Yeah, I was afraid someone was going to ask that. Look, there's not a right or wrong number. I'll tell you what I've seen. I've seen, anywhere from 5 to 20%. And, there's no right or wrong answer to that because it really depends on how much competitive pressure you're under. What you don't want to do obviously is mark up your insurance line item too aggressively and wind up losing a bid if you're in a hard bid situation. So that's kind of one way on the hard bid work, the public work and the private hard bid work. The owners protect themselves as they say, look, if you want to get too aggressive and overbid it, then you're going to lose the job. I think some modest markup is entirely defensible, it's entirely reasonable because, if you think about it, in many of these policies, you're also going to have deductibles, right? Well, if you just pass through your actual insurance cost, there's also an element of risk that you're taking that's not insured, and you've got a price for that too. And there's some contractors have very sophisticated models for figuring out what that right number is. They usually call it an insurance load. And they'll sit down at the beginning of the year with their broker, and if they have not a risk manager, but maybe a CFO or somebody, they'll sit down and say, look, what is our insurance? What is our annual insurance budget? What does it cost us? Not just the insurance policies, but what about the deductible losses we might have, right? What about the time and expense that the CFO has to spend, dealing with the broker and going through renewals and all of that stuff? Those are all legitimate expenses that should be accounted for and then theoretically baked into your insurance load, your insurance chargeback. So what most contractors do, not all, but most of them do, is they'll sit down at the beginning of every year after their renewal and they'll do that calculation and figure out, okay, what's my standard insurance load? What am I going to load up in every bid to make sure that I'm recovering those costs? And it could change by project, right? But usually there's a baseline number that most contractors will develop at the beginning of their year, their insurance year. And then they'll try to use that as a baseline for all future loading, future load conversations.
Great, thanks, Kirk. Let me advance.
Okay, and so probably many of you have seen some of these third-party certificate tracking companies. So MyCOI, Avetta, ISNet is probably the biggest one. You'll see these oftentimes if you're bidding upstream to a GC or an owner. Particularly the bigger GCs and owners will outsource a lot of their subcontractor certificate compliance to these firms. And we actually have we have our own in-house system that does this too. It's called CertSecure. And what these vendors do is their job is to take your customer, your owner's contract documents and the bid list basically, so they know which subs are going to have to provide certs, and they're going to chase you guys for those documents. So they'll give you a portal. Usually you'll upload the information. They'll check it. If it's deficient or missing something, they'll send an email or they'll call you or whatever. So many of you have probably, again, some of these firms are kind of a pain in the ass to deal with, but many of you have probably dealt with one of these firms in the past. If not, you're dealing directly with either the owner or the GC to make sure that you're compliant and the certs are in order and all the paperwork's right. So, okay, next slide, please. So some basic frequently asked questions. I'm not going to read them all. I'll just leave them and we'll distribute this later. But these are the ones these are sort of the ones we see all the time. And we'll touch on a couple of these here as we go forward. But again, I won't read these. I'll leave these to you to read later. Next slide, please. So contract review. So this is where we kind of get in the meat of what we're negotiating, what we're agreeing to, and what we got to make sure that we're covering. So next slide, please. So here's the basics. Talked about a few of these already. In every contract you're going to have lots of parts to it, but the two parts that we're talking about and we pay attention to are the indemnity provisions. Usually it's one section in the contract, and it's usually, if you're familiar with these things, there'll be one paragraph that doesn't seem to have any punctuation in it, and it's a run-on sentence. It's probably 400 word long sentence. I don't know why lawyers do that, but we see it all the time. It's terrible syntax. But as soon as you see that block of letters, that's probably the indemnity provision. So we've got to make sure that we and you both understand that indemnity provision and what it is that it's saying. And what an indemnity provision is just a legal, essentially, agreement between you and the other party, you and your owner, as to who's responsible for what and under what circumstances. It's all spelled out in that indemnity provision. If it's not in the indemnity provision, it doesn't happen. It doesn't exist. It's not enforceable. So it's going to be that's why it's such a dense document, is there's a lot in there and a lot of things have to be addressed. So first thing we do is look at that indemnity provision to make sure it's sort of in line with what we would expect. It's reasonable. It's not overly broad, et cetera. And then in another section of the contract, typically there's an insurance provision or insurance section. And that insurance section will spell out in some detail, or if it's public work or big private jobs, in great detail, exactly what insurance requirements you're going to have to meet. Limits, they'll talk about what kind of carriers you're allowed to use, certain size and class of carrier. Below that, they won't accept it. All the very specific language around endorsements, additional insured is addressed in there in detail. Everything that essentially you're going to have to comply with should be spelled out in that insurance provision. Again, if it's not in the insurance provision, that it's not a requirement, right? I mean, you're contractually agreeing to this, but they can't come back and say, well, that should have been in there, but it wasn't. Tough shit. It's not in there, so you're not obliged to comply with that. So, in a best case scenario, that insurance provision and that indemnity provision should match up, right? We should be agreeing to take risk, or you should be agreeing to take risk for which you can provide insurance in most cases. Because if you can't provide the insurance, then you're taking the risk uninsured. And that's not always a good idea. So those things should be working hand in glove. Those provisions shouldn't include any contradictory language. And we see this sometimes too in poorly written contracts where you'll read through the indemnity provision and it'll say, we're going to do this, we're going to take this risk and that risk. And then 2 sentences later, it says, you're going to take this risk and that risk. So it's got to be well written. And again, that's the job of the lawyers. They work through these things to make sure that they actually say what they intend them to say. And they don't always do that. These contracts have to be compliant with local, state, and regulatory and federal law, right? You can't write a contract that's illegal or that's contrary to law. So that's why in every state has a slightly different, in some cases, very different rules around contract law, tort law, construction defect law, all that sort of stuff. So the contract has to be written based on the state in which you're doing the work, because it's going to vary. A contract to hang drywall in New York City is going to look very different than a contract to hang drywall in Birmingham, Alabama, because the rules that you have to comply with in New York are different than the rules in Alabama. So it's got to be jurisdictionally specific. It's got to be relevant to the jurisdiction. It's got to be written for the jurisdiction. It's one reason why you see lawyers are licensed at the state level, because the state laws are so you can't be a lawyer and practice in 50 states. You can't keep up with it. It's impossible. So the insurance provisions, right? So that's the insurance section now, should be very specific. The more specific, the better it is for you. Where we see a lot of problems arise is when an owner has a really loosely worded insurance provision saying, yeah, you got to provide us GL, you got to provide us umbrella and an auto, and they don't specify how much or what it should look like. On the one hand, you might think, well, great, because that's easy to comply with. The problem is if you have a claim, or if you go in to have that contract in front of a judge to be interpreted, because it's not well written, it's not tightly written, you can actually find that the contract interpreted by the court instead of by you or by your owner. And that's not a good place to be. So we want these provisions, these insurance provisions, to be as specific as we can get so that we all understand exactly what our requirements are. So an example right below this, sometimes we'll see this. And again, this is where the little bit of a language thing makes a difference. In some cases, we see this provision that says, commercial general liability limits shall be no less than 1 million. Well, what does that mean? It means at least 1 million or more, right? Versus commercial general liability limit shall be 1 million. The green one is the better one because we're specific, right? The red one means you got to provide at least 1 million, maybe more, right? Well, if I'm representing you talking to the owner, I'm saying, look, what do you want, right? If you want 1 million, say 1 million. Don't say no less than, because that doesn't say 1 million. That sets 1 million as the floor. So we try to force them where we can. Again, this is where the negotiation part comes in. We try to force our clients' customers to be specific. We're not saying what the right number is. We're not saying you can't have 1 million. We're just saying be specific so that we all understand what the requirement is. And there's no room for error. There's no room for interpretation. And then again, many of you, not all of you, but many of you will be talking, negotiating this upstream with an owner or GC, but also you might be hiring subs. So you're going to be having the same conversation with your subs downstream. You want them to be specific to you as much as you want your owner to be specific to you, right? It's specificity is everybody's friend in a contract. So the other thing we want to make sure, and this isn't always achievable, but this is always the objective, is that if you're in the middle, so let's say you're a GC, you're acting as a prime or a GC, you got an owner upstream and you got subs downstream. We want to make sure that whatever it is you're agreeing to, whatever risks you're agreeing to take upstream, that you're able to pass most, if not all of those on through the downstream subs. Unless you're self-performing the work, which many of you, some of you don't, some of you, many of you do, but some of you don't. If you're not performing the work, then you need to make sure that basically 100% of the risk you're taking upstream is being passed downstream. Otherwise, you're stuck with it. So we call that flow down. That's a legal term. We also use it. Basically, it just means that everything flows up and down as seamlessly as possible. So whatever it is you're agreeing to upstream, you're also asking your subs to agree to downstream. So there's no mismatch, there's no disconnect, nothing falls between the cracks. So you'll hear this term used again a couple more times, but it's a really important concept for us in the contract review space. So next slide, please. So,
Oh, sorry, there is a question here.
sure, no problem.
Sorry. We are a SBE/DBE, but some clients want GCL 10 million versus our normal 1 or 2 million. How do you deal with getting an owner to accept our levels?
Well, if that owner is the federal government or the state of Texas or the state of California, not much luck in doing that. As I said, those owner requirements with the public work and the public finance work tend to be pretty rigid, and they tend not to negotiate much because they can't, because it's in the statute or it's in the bidding requirements. If it's a type of owner where they have the ability to negotiate, then what we do, and I can't respond to how your local broker or your local agent might handle this, but we tend to get very hands-on with our clients. And if we say, look, this owner, this developer, let's say, is asking for $25 million a limit for me on a project that I'm only doing like $400,000 of work on, is that reasonable? No, that's not reasonable. And we're happy to get on the phone with you and your PM or whoever it is you're working with on the owner side to say, just talk it out, right? Walk me through what your concern is here. Why are you asking for such big limit? We don't see the exposure. We can't argue with them, right? Because it's their contract. We don't want to make it a confrontational exercise, but we also need to challenge it when we think it's out of line, because we see that a lot. We see owners, we see upstream contracting partners ask for things that I personally think in some cases are really out of line, just out of line with the risk. So we'll call it out. That doesn't mean we're going to get them to change. I mean, they may still say, you know what, I hear you, but I don't care. It's my job. This is what I want. In that case, then you can go out. Typically, your broker can go out and either buy you some additional limit. Sometimes you can buy it on a project we call project specific basis. So just for that owner, and whatever that cost is, incremental cost, you pass through back to the owner. I mean, if you can't reason with them, I guess if they want to pay the bill, then they'll pay the bill. But that's definitely where we see those as pass-through costs or even markup costs. Is, if they insist on some unreasonable amount of limit of insurance, okay, just make sure they're going to pay for it. And your broker can get it. Typically, we can get it. So,
Thank you.
sure. So again, so this is the indemnity side, right? We talked about the insurance side. This is the indemnity side. Last thing I just want to reinforce again, this idea of flow down, that where we see most of the problems with a contractor who might be, in the middle, might be having some subs below them and an owner up, is this idea of them not having those provisions mirroring themselves. Both the indemnity and the insurance provision should mirror themselves. Next slide, please. So here from an insurance underwriting perspective, here's what the carriers are looking at. So all of this stuff we just talked about, right, is important. Number one, because it protects your interests. Number two, it's because it's a requirement of the contract. And if you don't meet the contract requirements, you're not going to get the work. But number three is it's also going to impact, in some cases, directly impact how much you're paying for your insurance, right? Because how you take risk and what you're agreeing to take and how well the contractual relationship exists between you and your owners has a direct impact on you as a risk from an underwriting perspective. So, in the old days, and I would say old days being, pre-COVID, before we got into this really hard market, underwriters would always talk about the importance of, hey, we only want to write contractors that do a good job of contract review. Okay, which sounds great. The truth of the matter is, half the time they didn't care. They weren't even looking. They weren't even paying attention. They wanted that, but they weren't checking. They weren't validating. They weren't really validating that the contractors were doing the right thing or the brokers were helping them do the right thing. Now the market's changed. We're in a hard market. We're still in a hard market, as many of you know, where prices are up and it's just harder to get stuff placed. And one of the reasons we're in a harder market is because the underwriters are now paying much more attention, much closer attention in many cases, to how well we with you, address this issue. Are we collectively agreeing to things that are reasonable, right? Because at the end of the day, it's, other than your deductible, it's your insurance company that's going to have to pay these claims. It's not you. That's what you pay them for. So we want to make sure that what we're asking them to agree to cover, again, is reasonable. Otherwise, if it's unreasonable, they may pay the claim, but they may be gone next year, or your rates are going to go up. So this is a really important part now. It's become an increasingly important part of how we try to get good, better deals, better renewals out of the market for our clients. Is we want to make sure that the underwriters understand that we're hands-on with our clients, because we have to be. And therefore, our clients are a better risk. Therefore, they warrant a better rate, right? They, don't raise their premium because they're doing the right thing. And you really have to talk about that. We have to message that. Your broker, your agent should be having this conversation aggressively with your carriers. If they're not, then they're probably not getting the best deals they should be getting out of the marketplace. And again, I re-mention again, there's different types of risks that are different types of projects, different scopes that drive pricing up and down. Again, for those of you that do the work in the residential space, you'll know that residential right now, whether it's apartments or condos or anything, has gotten really expensive, and it's gotten tougher to do because the risks are there. We see a lot of risks, a lot of claims coming out of residential construction on the construction defect side. In some cases, really tight schedule, mission critical stuff. We do a lot of data centers, and this is big in data center. Those things got to be up and operating. A stadium or student housing, anything with a really, really inflexible schedule is riskier, right? Not only from an insurance perspective, but for you guys, from usually you see delay and LDs and things in those contracts. Anything with a tight, rigid schedule is automatically going to be a riskier project for everybody. It doesn't mean you don't do it. It just means you gotta make sure that you're accounting for that risk correctly in your insurance load and in your sort of strategy of how you handle this. Stuff that's fast track, likewise, compressing the schedule. You guys are already stressed enough. Supply chains are already stretched thin. All that stuff. You're already working right on the edge of collapse in many markets already, subs and suppliers and things. And then you get somebody who wants to fast track a project because, again, they got to get it up or they got it leased up or whatever. All that does is add another layer of risk and another layer of pressure to everybody. Again, it can be done, but it's another risk that we want to make sure that we're accounting for in both the program structure and also in your cost structure. There are some states, and I don't know who the audience is today, but this list of states are kind of the bad boys. Again, New York is uniquely bad for this thing called labor law, which exists mostly in the boroughs in New York City, but technically it operates everywhere in the state of New York. For those of you that operate in New York, you're probably already familiar with this. For those of you that don't and don't intend to operate in New York, don't bother. It's a nightmare. You don't want to deal with it. Outside of New York, there's a number of states that are particularly difficult for construction defect for various reasons. Bad laws, bad case law, just really aggressive, plaintiffs' attorneys, a lot of different reasons. The poster children for that right now are Colorado, California, Florida, South Carolina, and Arizona. Those 5 states have gotten really difficult and gotten expensive from a construction defect perspective, particularly for residential work, anything residential. Commercial stuff, not so much. Industrial, streets and roads, really, it's not an issue in those states except for Florida. Florida's a tough place all around to do business right now. And then there are other types of risks that are present in certain states like Illinois and Florida. We call it action over. We will touch on that, I think, briefly in a minute. But again, all of these elements, construction defect states, the bad states for action over, or what we call horizontal exhaustion. And then, of course, you've got states that are cat exposed. Now, that's more of a property issue. But for those of you that are going to be responsible for builder's risk or installation floaters, that's going to impact you directly. So if you're building an apartment building in Coral Gables, Florida, and it's going to take you 2 years and you're going to have 2 hurricane seasons to live through, you can be damn sure your property insurance is going to reflect, or your builder's risk rate is going to reflect that wildly increased exposure in South Florida or New Orleans or, Panhandle, anywhere in the Gulf Coast. So these are all, again, all of these are doable. We do lots of business in these parts of the country. We just want to make sure everybody's accounting for the cost, because you need to recover it in your contract. You can't go back after and say, I missed it. Oops, here's another bill. That's probably not going to fly. So we just want to make sure we account for this upfront in your contract. Next slide, please. So all of the things that we've been talking about, the overarching theme of all of this is all about risk management, which, by the way, is what you guys do every day, right? As a contractor, your main job is managing risk, right? You got to figure out, can you do this work safely? Can you do it competitively? If you're a GC, can you find the right subs that aren't going to flake out on you? If you're a sub, can you find the right GC that's not going to stiff you payment, right? It's all about risk management. Everything you do every day is risk management. So on the one hand, what we do and what you do is almost identical, right? We use different jargon and we're focused on different parts of the risk profile, but we're doing the same thing. We're trying to help you, or trying to do this together, but we're trying to make sure that collectively we keep each other out of trouble. So again, write down the list here. One way we do that is make sure that we all understand exactly that contract language, what it says, what it intends, and what's your scope of work, and making sure that those things all match up. Make sure that we're, negotiating equitable contracts, right? You're not asking a sub to do something that is unreasonable because they have no control. And likewise, you're not agreeing to something from an owner to take a risk that you have no control over. That's not fair. And also doesn't make sense. We really need to understand this risk versus reward in contracts. And this is where, we would never tell one of our clients, hey, don't do this job because it's not worth it. But what we will do is flag the fact that, hey, this is going to be the cost for you from an insurance perspective to comply with this requirement in this contract. Do you have enough margin in that contract for that to make sense to you? And you guys will make the decision, but we will be, I don't want to say aggressive, but we will not be shy about calling that out, because we feel that's part of our job, right? You guys are in this to make money. You got to make a margin. If your margins don't hold up, you don't stay on in business very long. So one thing that can really erode your margin is missing on the insurance line item. That's a really easy way to lose money on a job. So a couple things, this sort of risk reward that's the juice worth the squeeze, right? That's the concept. Is it worth it or not? Because you can do all kinds of work, you can bid all kinds of jobs. You do this every day when you're estimating is, do I want to bid this job? Can I make money on this job? One of the line items is insurance. And if you've underbid your insurance, then you're going to find out your margin just goes away when you do that. Last couple, again, reiterating these things, and be surprised how often we see clients sign contracts without necessarily completely going through them. But once you sign that contract, we're done. I mean, unless the owner wants to be gracious and allow you to do over, once you sign it, you're committed. So we really, really prefer and really want to have an opportunity to make sure that we all understand what's in that contract before you sign it, so that you priced for it, you've accepted the risk knowingly, and we all understand what to expect going forward. Because also your broker, your agent's got to make sure that your insurance carriers are aware of what's going on. I mean, did you just sign a contract and sign your insurance company up for something that they didn't intend to take? So it's really important to make sure that we're all on the same page here. And the last thing, talked about this before, but I cannot overstate the importance of a really well-written contract. Some of the best insurance, the cheapest insurance you will ever buy is again, probably whatever you're paying, $400 or $500 an hour, $600 an hour to your attorney to write a good contract. That's way cheaper than any insurance you'll ever buy. And once you do it once, you can reuse that contract again and again, oftentimes. So we, in general, and this is at a kind of very high level, the way we approach all of this is, your first line of defense is contracts, is well-written, well-negotiated contracts. Second line of defense is your safety and quality program, right? Make sure that you're running a safe shop and you're building quality product that's not going to come back and haunt you 5 years from now. Whatever's left over is what we throw in the insurance bucket, because insurance is the most expensive, least efficient way to solve all of these problems. It's necessary, but we don't want you to buy any more insurance than you absolutely have to, because it's not efficient. It's expensive and it's not efficient. So, next slide, please. So on the risk transfer side, next slide, please. So we've done the review. We now know what's in there. Now we start talking about, okay, how do we share the risk? How do we pass this risk back and forth and sort of shift it to you, or I take it from you, right? We do that through the indemnity provisions. We talked about that before, mentioned it again. That's the document. That's the section of the contract that lays out exactly who's taking what, who's responsible for what, and under what circumstances. The insurance, which is that next provision, is really just the backup to the indemnity provision, right? The insurance is legally binding, but it's not the framework it's not what they're going to enforce on you. They're not going to enforce the insurance provision. They're going to enforce the indemnity provision. So we got to make sure that whatever the insurance says lines up with what you're agreeing to in the indemnity provision. Again, that hand in glove concept. And again, this applies to all these different coverages, GL or comp, auto, excess, anything else that any other exposure you might be agreeing to in the contract. So let's talk about additional insured. That's a really important provision. It's part of a general liability policy. It's also a legal term. So again, many of you know this, so pardon me for belaboring this, but just for those who are not as familiar, when I name you as additionally insured under my policy, so I'm a sub, you're a GC, your contract says you're going to name me as additionally insured under your policy. What I'm saying is my carrier, in the event there's a claim, my carrier is going to step up and not only protect me and indemnify me, they're going to protect you, the GC, and indemnify you too, for my work, for my problems, for my bad acting, right? That it's designed to do that. It actually provides, it doesn't just extend the coverage, but it also extends the defense benefits. So not only is the GC protected by my insurance if I screw up, but if I get sued and the GC gets sued, my insurance company is going to defend the GC too. We owe them that defense. That defense provision is critical for additional insured. The only way that can happen in an insurance policy is through this additional insured endorsement or this language. So it's really important how it's written. There's different versions of this. We call them additions. I will talk about in a minute. But this is one of the core concepts. If you take nothing else away, this is one of the things that we spend most of the time on, is this additional insured language. What does the contract say? How specific is it? And then what does your insurance policy say? And can your insurance policy meet the requirement of the contract? And if it can, great. If it can't, you got a problem. So we have to address that, right? And then waivers of subrogation. This is something we talk about. You probably have seen and heard as well. It's a legal term, but it's also an insurance term. And all a waiver of subrogation means is that if I buy insurance on so let's say I'm an owner and you're going to build an apartment building for me. You're the GC and I'm saying, build me an apartment building. I'm going to, under the property policy, I'm going to ask you, I'm going to require you to buy builder's risk too, because I want to protect myself for the property risk, or you and me for the property risk. And under that builder's risk, there's typically what's called a waiver of subrogation. And it, again, doesn't just apply to builder's risk, but this is the example we use. So what the waiver says is that if I buy, or if you buy a builder's risk policy to protect my project until it's completed, right? And then there's a claim, then your carrier is not going to be allowed to pay the claim and then somehow or another come back after me if I contributed to the negligence and try to collect some of that money back from me. You can't subrogate. Subrogation is that idea of one carrier going after another carrier to try to recover money. Waivers of subrogation in the policy and in the contract say that my carrier is not permitted to do that. So I'm buying builder's risk, and if I have a claim, my carrier is going to pay it, and they're not going to try to chase anybody to recover that money. We're just going to own the claim. Those things exist on the liability side as well as the property side. They're important because, you know, in the contract, if you're asked to waive subrogation, right? If you're asked to agree to a waiver of subrogation, great, you sign that contract. But if for some reason your insurance policy, your carrier is not willing to go along with that, then you've just committed, you know, your carrier to something they're not going to do. So you've now breached your own contract, right? And you've also breached the terms of your insurance policy. So when we see waivers of subrogation in contracts, number one is we ask, is it reasonable, right? Does it make sense? Yes, no. And then does our insurance program, whatever policy we're talking about here, does that insurance policy permit me to waive subrogation in my contract? And typically they do, but we always want to make sure that's the case. Next slide, please. Oh, do we have any questions? I see a couple pop.
Oops, sorry about that. We have a question from an attendee who wants to know if there are any tips or tricks on how to negotiate changes to the indemnity provisions. He says typically these larger GCs say, quote, cannot change, but we know this is not true.
Yeah. Well, so kind of like negotiating insurance, right? It depends on who the ultimate owner is. If that contractor's client, their owner is, the state of Texas or the city of Los Angeles or the federal government, there's a good chance they can't move on that either because what they're trying to do is the same thing we're telling you to do, which is whatever they're agreeing to the owner, they're going to make sure that they want you to agree to the same thing. So typically that indemnity provision that you're seeing is a mirror of what the owner's requiring of them. So could they negotiate and loosen it up or change it? Yeah, they could. But is it smart for them to do that? Probably not. For the same reason we wouldn't want you to do that, right? Because those things should flow seamlessly up and down. Now, if you run into, sometimes that's not the case. Sometimes we see GCs, especially the big guys, who tend to abuse their subcontractor pools sometimes because they can put, really onerous indemnity provisions on their subcontractors. We're not allowed, and I'm just saying this out loud, we're not allowed to give legal advice, really. So the indemnity provision is a purely legal agreement. It's a legal provision. So we can't tell you how to write it, but what we can do and what a good broker should be able to do is say, look, this looks broader than I'm used to seeing, right? And raise the flag and say, hey, you might want to take a look at this. But then it becomes a commercial conversation, right? It's a negotiation between you and the GC. Whether they're willing to give in on it depends on a lot of things. Can they, right? Do they have the contractual latitude with their owner to do that? Number one. Number two is if it's hard bid and they got, 5 responding bidders and they're all competitive, maybe they're less inclined to negotiate. If you're the only bidder or, if you're a unique, you're a sole source, then they're probably going to negotiate more with you because they need you on that job. Right? It's a commercial aspect. There's really not an insurance or legal thing. It's mostly a commercial. Will they negotiate? Of course, if they want to or they need to, they will. Otherwise, no.
Good advice. I will advance.
Okay, so here are the issues on indemnity, right? So real simple questions, right? When we look at these indemnity agreements, the 3 key questions we got to understand when we finish reading that is who is indemnified, right? Who are the parties? Who's being indemnified? What are we indemnifying them and what are they indemnifying us for? And then how's this defense issue handled, right? And that's where the AI, the additional insured, comes in. Those 3 simple questions drive everything else we do from an insurance perspective. So next slide, please. So, where are you going to see these? You see them in every contract you're going to sign. If you're a sub, you're going to see it with your GCs. If you're a GC, you're going to see it downstream with your subs. If you're a design firm and engineer, you're going to see it with your owners or your GCs if it's design build, right? Any contract you enter into will or should, if it doesn't, I flag that too. It should have an indemnity agreement because that's what frames up who's taking what and how you're sharing that risk. And obviously, probably many of you are familiar, there's a lot of these standard forms, the AAA forms, which most of you probably use. There's other versions of that. There's consensus docs. And oftentimes we also see, states and certain agencies of the federal government will have their own contract forms that they've developed over the last 500 years or whatever, and they prefer those. So every contract is going to look different, but every single one of those contracts is going to, somewhere in that contract is going to be this indemnity provision. So sometimes you got to dig through it to find it. And in most cases, no surprise, it's always going to slant toward in favoring the upstream partner. So if you're the GC and you're dealing with the sub, probably your indemnity agreement is probably likely going to favor you a little bit more than the sub. I mean, just by design. Flip side is also true. If you're a sub and you're dealing with, Walsh or, Dunn or one of the big contractors, they're not probably going to negotiate much and they're not going to loosen up on that. So you're going to have to live with their indemnity agreement, knowing that it favors them. You just got to make sure that even though it favors them, you can still meet the requirements. So you're not exposing yourself. It's just because it favors them doesn't necessarily mean it's bad. It just means you need to be aware of how it's favoring them so that you can comply and you can price for it, right? This is part of the pricing conversation too. Next slide, please.
Great. Quick question too from an attendee, very specific. How do we purchase hazardous materials insurance and who sells it?
Yeah, so I'm assuming you're probably talking about pollution liability, things like that. That has historically been sold as a separate standalone policy. Many owners and many GCs now have that as a standard requirement with their subs. Not all, but many of them do. So if you don't own it, or sorry, if you don't purchase pollution right now, you haven't had to purchase pollution. Your agent, your broker, whoever you deal with now, whoever you buy your GL and your comp and your auto from, should be able to set you up with that. In most cases, it's not real expensive. You can get a real basic pollution liability policy for most smaller subs for, $5,000-$10,000 maximum, sometimes cheaper than that. And sometimes you could combine that with your professional liability if you buy E&O insurance as well. So there's lots of markets that write it. If your broker can't find it, isn't familiar with it, again, reach out and we'll figure out a way to get you sorted out.
All right, let me advance.
So indemnification, we've been talking all about this. There are three basic forms of this, right? And it's all based on how it's worded. So there's the so-called limited form. And under the limited form, what that means is that's the narrowest form of indemnity, which means that, the upstream partner, the owner is forcing you to take the least amount of risk relative to the other options, right? It's more equitable. It's basically the way limited form works is you're only going to be paying, you're only going to be held liable to the extent that you caused the problem, right? And in proportion to your problem. So this sounds like it's a really exact science, but it's not. When let's say you're a sub and you're pouring a slab and, it's set and you start doing vertical work, you're framing up on it. And, 5-6 months later, the slab cracks. And if somebody figures out that you didn't put enough fly ash in, or you didn't, the mix wasn't right. Under that scenario, the concrete subcontractor is obviously liable, right? Because they presumably did something wrong. They did poor work or they didn't do it right or whatever happened, but they're at fault for that. Under the limited form, the way the claim gets assessed is, let's say, that's probably a terrible example, but let's say it wasn't entirely the contractor's fault, right? Maybe there was a sub to them, or there's another partner who was supposed to check it or whatever. So under the limited form, some insurance, either the insurance company settlement, the claims guy, or a judge, if you go to court, is going to say, okay, well, my assessment is there's $1 million of damage and you were responsible for 60% of it and the other guy's responsible for 40% of it. So that's how they assign liability. They'll literally say you're responsible for 60% of that $1 million. The other guy's responsible for 40% of it. That's called proportional negligence. That's typically what we see in limited form, because it's you're going to be held responsible, but only to the extent that you caused the damage and in proportion to that. As opposed to intermediate form, which is yellow, which is terrible. You can't really see that. My apologies, but intermediate's the next one down. What that says is, same scenario. You poured the concrete. If you contributed at all, even 1% to the screw up, you're going to be paying all that claim. You're paying 100% of it. That's the common way to do it now. That's the most common way, is the intermediate form. Broad form still exists, and this is going to blow your mind, but broad form would suggest that even if you didn't do anything wrong, you could be held liable. So we just had one of these situations recently where we had a general contractor they just topped out a mid-rise building for an apartment in Atlanta. And the owner decided that they were going to have a little party in the building, the unfinished building, kind of to celebrate the top out. So they had, I don't know, 40, 50 people on the top floor. It's like 12-story building. And they set up drinks and everything. And one of their guests got drunk and wandered off and fell down an elevator shaft and killed themselves, right? The general contractor was held responsible for that, believe it or not. Even though they had nothing to do with it. They weren't on site. They had nothing to do with the party. They had nothing to do with that risk, because they signed a contract in the indemnity that said that they were going to accept negligence on a broad form basis. They're now responsible for that, and their GL carrier will have to pay that claim. So let's go to the next slide. I'll just explain this in a little more detail. So here's what they look like in the indemnity provisions. Here's the language that typically gets used when we're looking at a broad form versus an intermediate form versus a limited form. Again, you don't have to read this now or memorize it, but we'll leave this with you. So when you're reading through that indemnity agreement, trying to figure out, okay, is this broad and intermediate or limited? Because it's not going to say that. This is the language that's typically used. And if you see this language highlighted, that's the trigger that will tell you, oh, this is broad form, this is intermediate, this is limited, right? So again, we're going to move on here, but you'll have this slide available to take a look at on deeper if you want. So next slide, please.
Kirk, we do have a question
Oh,
here.
sure.
You may have touched on this. When is the best time to engage a broker? Is it at bidding period or post award?
Yeah, I mean, bidding period. I mean, post award, you've already been awarded. You already priced it, presumably. You may have even signed the contract, or you're about to sign the contract. You're in a much better position to negotiate around stuff that you don't like if you address it up front during the bidding phase. You may still be able to, kick save it before you sign the contract, but it's a lot harder. And probably if it's hard bid, you've already put a number out. So if you miss something or you need to account for something else, too late for that. So earlier the better, as early as possible. Earlier is always better.
Great. Thanks. Let me advance.
Sure. So we talked about that broad form, right? That broad form is only really enforceable now in about 5 states. So again, that example I gave you sounds nuts. How in the world could GC be held responsible for an owner having a party at the job site, right? The GC wasn't even there, but it's true. There are still 5 states that permit that sort of language in contracts. So if you are, silly enough, or you miss it and you sign a contract with broad form indemnity in those 5 states, they're going to hold you to it. You're going to have to live with it. The other 45 states have said, you know what, that's completely ridiculous. We're not going to enforce it. Even if you sign a contract that says broad form in those other 45 states, you can't enforce it because the courts have said that's ridiculous. It's not fair. But I would still make sure that you're not signing an indemnity provision, even if you're operating in those other 45 states that has that language, just to be careful. And then there's 27 states that don't permit the intermediate form, right? And there's reasons for that, but basically they're saying we don't want to get in the process of trying to figure out this proportionality thing and what percentage of responsibility we should assign. If the GC or the contractor touched that project at all and has any responsibility, they have it all, because it's easier for the courts basically to figure that out. So the reason we spend some time on these 3 different types of indemnity is because each one of these indemnity forms, limited, intermediate, and broad, is then tied to an additional insured endorsement. So depending on the nature of the indemnity that you're agreeing to in the contract, we have to use a different endorsement for the general liability for your additional insured language, because each one's different and they read differently. So if we go to the next slide, I think we expand on this a little bit. Well, we will in a minute. So again, under the contractual liability portion of your general liability policy, so GL, you guys are familiar with, you all probably buy it. There's a little subsection of that policy that talks specifically about this idea of contractual liability. And that is not just, that's not just the bad things that can happen to you and people slipping and falling and stuff blowing up, but it's what is it you're agreeing to in your contracts, right? That's the contractual liability portion of your general liability policy. So one of the key phrases, the key terms we pay attention to is in that contract, in that insurance policy where they define everything. One of the things they define is contract, the word contract, and the word insured contract. What is an insured contract? Well, what does the policy say, right? You got to kind of, and this is where it gets in the weeds, but your broker, whoever it is that's going to be helping you with this, needs to understand, and yet with your particular insurance company, how do they define this in the policy? Because that matters, because you're now assuming liability in these contracts. The policy will specifically say, we're going to cover things that you agree to in a contract, but how do they define contract, right? Is it written? Is it oral? Is it informal? Is it formal? What constitutes a contract? So I will say, as a general rule of thumb, we talked about this before, that means written contract. And this is one of the most common mistakes that I see get made with these contracts is, you're a sub and you got a GC or an owner you do a lot of work with, and let's say maybe they need a little emergency call, and you spin up one of your crews and you go out and you deal with it, right? But you don't have a contract in place because they're an owner and you're going to bill them, right? They're good for it. Awesome, right? That you've got that relationship. But from an insurance perspective, you're basically self-insured on that job. If you don't have a written contract or a PO at least in place with that truck roll, with that run, if you have a problem, you could be insuring that yourselves. Most insurance companies and most insurance policies on the general liability side now specifically require a written contract to be in place and executed in order for your insurance to be effective, right? In order for it to pay off prior to starting the work. So they're not loosey-goosey like they used to be, where, so it's an owner we've done all this work for, we had an implied contract, we had an oral agreement. Those typically are not going to fly anymore. You got to have something written down, specifically written down, in order for your insurance to respond. And there's other things that may not necessarily come with the contract, right? That or may not be covered for good reason, right? Breach of contract is not something your insurance company or GL carrier is going to pay for. That's a that's a legal commercial risk. Guarantees for performance of work, faulty workmanship, typically, for the most part, those are surety and those are binding issues. Oops. Dan, can we back up one slide?
Sorry, yeah.
Oh, one more. Sorry, how we get just a couple. One
Am I
more.
going in the wrong direction?
Oh yeah, we want to go backwards.
There we go.
There we go. So some other stuff that's not going to be covered under your insurance. Again, breach of contract, your performance issues. Somebody raised a good point about things like pollution. Pollution liability is explicitly excluded under the GL. So if you don't buy a separate pollution policy and you're agreeing to cover pollution risk in your contract, then you are uninsured. You are self-insuring that risk. Again, there's solutions for all of this, but you got to make sure you know what you have and what you're agreeing to. And then things like government imposed fines, penalties, we can't ensure that. The legal system won't allow us to do that. Okay, next slide. So additional insureds, spend just a couple more minutes on this and then we'll wrap this up. Next slide, please. So again, just reiterating, what is an additional insured? An additional insured is an agreement, or in the case of an insurance policy, it's an endorsement to a policy that basically says, your insurance company is going to extend your coverage to your client, your customer, your owner, whoever it is you're required to. So you're buying insurance to protect you, but you're also now buying insurance to protect them. It's different than indemnity, right? It operates independent because indemnity is a legal agreement. Insurance is an insurance contract, but the two things should basically, work hand in glove, right? They should say the same thing basically, but they do operate independently of each other. And then different courts can treat this additional insured language differently. So even if, and this is the maddening part of our business, every state's got their own rules, right? You have some states that permit that broad form indemnity, others that don't. Even in states where, let's say there's broad form indemnity, you could run into a court that says, you know what, this is what the state law says, but I don't interpret it this way. And I think it means something different. And, there you go, right? You got a contract, you got a judgment from a lawyer, from a judge saying something that you didn't expect, and it happens. We try to account for that in the policy language. And then normally the way the carriers are going to respond in most cases is they're going to give you the benefit of the doubt. If we get a judgment out of a court that we don't expect or that's novel, right? Carriers typically pay those claims, but then they're going to take that fight to the court system, to the Supreme Court of the state or whatever they have to do. But this happens, and it happens more often, frankly, than you'd expect. And then, this last thing about the indemnity and sold negligence, broad form things, we talked about that. Even if, and this is where it gets a little nuancy, but even if in the state in which you're operating that they prohibit broad form indemnity, right? If you've signed a contract that binds you to that, you could still be, the GC could theoretically still enforce that, right? Not through the statute, through the state law, but through the contract law. So that's why we don't want to rely on, if you're working in a state that we know doesn't permit broad form indemnity, you just don't worry about it. So you don't bother with the indemnity because it's not going to hurt you anyway. It can still come back to hurt you because you still signed a contract saying one thing, that you're agreeing to do this. Even if the courts don't enforce it that way, your owner could. So we really have to pay attention to that language. Next slide, please. I see a couple questions. You want to take those or move on? Okay, we'll move.
I think we have covered those to this point.
Okay, so just reiterating a few of these points, right? Advantages of being additional insured is it prohibits that, it can prevent that subrogation thing. It protects the owner or whoever it is you're working for. It protects their insurance so that your insurance is going to pay, not theirs, if there's a problem. Again, assuming you made the mistake or it's your problem, your insurance should pay. It provides them with direct access to your insurance as well as the defense, which is a really important thing. Next slide, please. So some other considerations, we'll just high step through this. Again, there is no, this first red line piece is, I put this in red because I wanted to reiterate again, the importance of being specific in the contract. So for example, we see a lot of contracts that say, you know, I'm the GC, you're the sub, you're going to name me additional insured under your GL and your umbrella and a couple other things. But they don't say what endorsement language, right? What addition of additional insured they want. So that means, in theory, that if you've got 2 or 3 different versions on your policy, which you could have, they could take the most liberal, the most broad version of that if there's a claim. Because your contract didn't stipulate, your contract wasn't specific. So if we're representing you as the sub and you're negotiating with the GC or an owner, and they say, we want you to name us additional insured, we're going to go back to them and say, what kind of additional insured? Be specific. What additional insured endorsement language do you want to use? And if they don't know, then we're going to propose one. But again, we have to be specific. If we're not, then it could get interpreted more broadly than we intended to do. And we haven't priced for that, or we haven't counted on that yet. Again, it's got to mirror the indemnity provision, a couple other things I mentioned. Usually when you negotiate that additional insured, it applies not only to your GL, but also your umbrella. It follows form, as we say. So you really should only have to do it once for the GL. There's some other things we also add, which we'll touch on briefly here in a minute, primary and non-contributory language, and we'll touch on that as well. Last point I'd make, that last highlighted item, is we talk about additional insured. There's some other jargon we use. There's a thing called additional named insured and a named insured, just to further confuse you. So in the insurance world, the named insured is you. Whoever's buying the insurance and who's the primary insured, if you will, is the named insured. You could also have an additional named insured. Let's say you've got another company that you work alongside with, or common ownership maybe, or a subsidiary or whatever, but you want to have them show up on the policy alongside you. We can list that company as additionally named insured, but they have to, there has to be a connection, right? There has to be an ownership or control issue. That's different than additional insured. Additional insured is just this extension that we provide to anybody who requires it to give them the benefits of your insurance policy. Sometimes we get asked, or I've been asked, hey, my GC, the owner wants me to put them on as a named insured on my policy, or additional named insured. Hell no, they should never do that. There's no reason for them to do that. By putting them by adding them as additional named insured, you can't add them as a named insured because that's already you. But by adding them as additional named insured, not only does that give them benefits of your insurance, but it also gives them control, right? Who pays the premium? What carrier do I want to use, right? You're giving them control that you do not want them to have, which is control over your insurance program. They should benefit from it, but they should have no control over it. So just make sure that if you ever see someone asking you to have them named as additional named insured, I would immediately pause the conversation and either call your broker or ask them, what are you trying to do here? What's the objective? Because there's no need for that. Next slide, please. We'll skip these. We'll leave them in just so you can read them. But all of these things we've talked about, these different types of additional insureds, this is what it looks like. This is just one sample from one insurance company. But if you dig in here, this is what the language actually looks like in the policy, which is going to bore you to tears and probably got better things to do than read this. But this is what it looks like in the wild, basically. This is how it operates in your insurance policy. So this is for the premises, which is the insurance, the liability that covers you while you're doing the work. So slips and falls and fires and property damage that you could cause. And then the next slide, please, is your completed operations. This is very important. So this is the insurance that picks up after you've completed the project, that protects you and them against future construction defects if they happen. So we won't belabor this. Next slide, please. So again, just reiterate, we got these three forms of indemnity: broad form, intermediate form, limited form. Each one of those is tied to a different version, a different edition, we call it, of the additional insured. So the broad form is the broadest, right, by definition, and the language, the edition we use is this kind of code at the top, ISO CG 2010 2037 1001. That's literally the name of the form. The secret here is the last four digits, the 1001. You'll notice, and the next one down, the 0704 and the 0413. Those are dates. So that's October of 2001. The next one is July of 2004. The last one is April of 2013. The reason that's helpful is a general rule of thumb, the newer of the form, the more limited it becomes. So the broadest form is the 1001, the 2001 form that's been around for 25, 26 years. Still used a lot. But it should only be used, you should only use that, you should only be asked to provide that endorsement if you're doing work for an owner or a GC that's operating in one of those 5 states that still permits broad indemnity. Because if it's the other 45 states, there's no need for this form, because they don't even permit this form to be used in those other 45 states. For the majority of states that you're going to operate in, or frankly, all of them in most cases, the 0704 version, which is the intermediate form, is the most common and the most reasonable form to use. If you can get away, if you're a sub and you're being asked by an upstream owner and they let you provide the 0413 version, great, that's even better. But what you're going to see most of the time is going to be the 0704 version. So here's where it gets tricky, right? You could theoretically have a GL policy that provides you all 3 of these forms, depending on which contract you're going to sign. And if you don't stipulate in your contract which form you're offering, they could pick any one of these. And usually if the attorney is going to pick the broad one, they're going to say, well, we didn't specify. So we know you have the 1001 form on your policy. So that's the one we're going to use. If you stipulate in the contract which one, they can't do that. It's called liberalization. So that's why it's important to be specific. Next slide, please. So I won't read this, but this is how they all lay out. This is the language. This is the different forms at the top. We talked the CG 2010, 2037, 0704, et cetera, et cetera. And this is what the language looks like in the policies for each of them. So we'll leave that with you when you get really bored and want to read something to put you to sleep. This will do it, I promise. Next slide, please. So waivers, last thing, I think, and then we're going to wrap it up. Next slide, please. So we already talked about what a waiver of subrogation is, basically. So hopefully that's pretty clear, but here's what it looks like. So sometimes the language, again, will vary by contract, but usually the provision of the header will say waivers of subrogation or something like that. So that'll be your cue. There are only certain policies that you can do this on. You really can't do this on an auto policy or on a work comp policy, but you will see this commonly required under GL, umbrella, and property policies. It's very common for those types of policies. If you see someone asking for it under a work comp policy, it's probably a mistake, or somebody just cut and pasted a contract and they didn't check that, because there's really no way to waive, there's no need and no way to waive subrogation under work comp or under most auto policies. Next slide, please. So again, just like the additional insured, it's got to ask for and stipulate that you're going to be giving a waiver of subrogation in the contract first. And then if it's in the contract, then we got to check with your carrier to make sure that they're willing to do that, right? Most are, but we want to check to make sure. It's got to be both, right? It's got to be in the contract, and we got to clarify with the carrier that they're agreeing to it. And then you're fine. Then you're good to go. There are some situations where waivers of subrogation are automatic. Usually we write it on an automatic basis. Most carriers offer it. Most brokers should be asking for it on an automatic basis. So that basically means anytime you have a contract that requires it, it's automatically going to be provided. That's the best way to do it. Then you don't have to keep going back to the carrier every time you have a contract. There are some circumstances where they can't do that. Here's the situations. I won't have to read it. I won't read them to you, but there are certain circumstances, unique circumstances where that's not necessarily going to work like that. Next slide, please. Last, I think on this, oh no, that's the same slide. One more. Other direction. One more. Oh, okay. The other thing we see commonly is this primary non-contributory language. This also is an endorsement and a legal term. So you'll see it in the contract. And then there's a matching endorsement on your GL and certain other policies, typically property policies, that will say the same thing. That will say, if you're required in written contract to provide this, if we're required to be the primary and non-contributory carrier, which means we're going to pay first, and we're not going to ask somebody else, some other carrier to contribute with us, then that's fine. We'll do that, but it's got to be in the contract, and then we'll agree to it. So again, it's got to be in the contract. Next slide, please. And then last one I'd mention, because we're seeing this more commonly, this so-called alternate employer endorsement. So more and more frequently now, we're seeing GCs and subs, augment their staff by either PEOs or, now we're not talking about subcontractors. We're talking about you bringing on crews, you're bringing on labor on a part-time temporary basis for a particular job. So this would also doesn't apply if you're a union and you're pulling people in from the local hall. That's a different scenario. This is where you're bringing in someone who is not normally your employee. They're not a subcontractor, so you don't have a contract with them, but you're using them to basically augment your staff or your field crews. In those states, every state but Texas, where you're required to provide workers' comp, if they're not an employee of yours, then they're not covered by workers' comp unless you add this endorsement, this alternate employer endorsement. So for those of you that do this, if you're not a union shop, again, this doesn't apply to union hall labor. And you have this situation where periodically you might hire, surge staff or augment your staff with local PEOs or whatever. You need to make sure that your broker's got this endorsement on your general liability policy. And I think I believe this fits on both the GL and the comp, but basically you need to make sure this endorsement is in place. Because what this says is to your carriers that in those situations where we're hiring temporary staff, we want you to treat them just like our employees for workers' comp purposes. So we're compliant, and also they can't sue us and claim lost time or wages, and it's not covered by your comp policy. So this is a really important one. We see this missed a lot. And this is something that we see a lot more of now than we used to see 10 years ago. Next slide, please. And then action over indemnity. Probably not going to go too far into this, but this is unique to a couple of states. The worst states, or the most difficult states, are New York and Illinois. I happen to be based in Chicago, so I am painfully familiar with this situation. For those of you that operate in New York, you may be familiar with a term called a Kotechi waiver, which is right at the bottom there. If you're not, don't worry about it. It's a case that became famous, and now they actually have the whole coverage thing named after it. But basically, this just says that there are situations in which this is really more of a GC exposure, but sometimes we see subs with this too. So let's say I'm a GC and I hire a subcontractor, and that sub is doing work, and one of their crews, one of their employees falls down and gets hurt, right? Well, what should happen? What should happen is that sub, that employee should file work comp against the sub, right? That's work comp. That's what it's there for. Well, in certain states, Florida, Illinois, and a couple other states, not only in theory can that employee collect comp from the sub, that employee could sue the GC and the owner as well. And what they'll do is they'll sue the GC and the owner and allege that GC and owner had an unsafe work site. That's why we got hurt. They can double dip, both work comp and general liability. And it happens a lot. So there are ways contractually to limit that. This Kotechi waiver thing is one way that GCs try to protect themselves in Illinois. But what we want to make sure of anyway is that in those states where this is an exposure, that we understand that the carriers who write the work comp and the general liability understand that this could be a risk, because this could happen, right? And if it happens, we want our GL carrier, which is where this claim would land, we want our GL carrier to agree that they're going to respond to these claims. We don't want to wonder. We want to make sure. And again, most carriers, most brokers who do this for a living, and most carriers who specialize in construction automatically price this in, right? It's a risk that they understand, and they priced it in. Where we see this as a problem is sometimes when you deal with a local small carrier, or maybe a local broker who doesn't do a lot of construction, and they put it with, a State Farm, or they put it with a small carrier who might not necessarily specialize in construction. Their form is not necessarily designed to cover this. So then you got to do a little digging, and you got to have a conversation with the underwriter and say, hey, look, I'm working in a state where this is a risk. Are we cool? Are you going to cover these claims if they happen? So call it out, because it's a real problem sometimes. Next slide, please. And then blanket for the additional insured, for primary and non-contributory, for all these other things. We like to write this on the so-called blanket wording basement or blanket wording additional insured basis, which basically just says, hey, we're gonna have an endorsement on our GL policy that says anytime we have a contract that requires us, a written contract requiring us to name additional insured, you're automatically going to agree to do that. Same thing with the waivers of subrogation, same thing with the alternate employer, same thing with the primary non-contributory. Most insurance companies that specialize in construction are used to offering this, and they frankly expect you're going to ask for it, so they do it. This is just something that makes the administration of this a little easier, because now we don't have to add a separate endorsement every time we do a contract. We need these things. So it's a really nice efficiency tool. Next slide, please. So one more slide, and we'll, again, you don't need me to read these to you, but here's just a kind of a list of, general do's and don'ts. So this is from the perspective of you transferring risk to somebody else. So this would be, for instance, you being as a GC and trying to push risk down to a sub, right? That's the perspective of this slide. If you go to the next slide, this is in the other direction, right? Now you're a sub and you're having to take risk from a GC or an owner. Here are the do's and don'ts. And again, these aren't all inclusive. There's probably things that, some things you've never seen that you never will see that aren't a concern. Maybe things that we haven't seen that's not on this, but this is the most common stuff. Tips and twos. And the third one more slide, is this additional insured status. So this applies in both directions. If you're upstream and requiring your sub to provide you with additional insured status, these are the do's and don'ts. Same thing applies if you're a sub and you're being asked to do this. These do's and don'ts still apply to you too. So this is a little cheat sheet we put together. One more slide. Okay. Worry out. How about that? We've still got 10 minutes left. Don't need to take it. If you got questions, we can jump on a few of those now too.
There is a question from an attendee who says, we offer as a master agreement with a GC as a sub. Should we expect to have to deliver an insurance when it is not a quote project specific scope?
Yep, great question. I didn't mention master agreements. Sometimes we call them MSAs or master service agreements, but those are being much more commonly used now because they're just more efficient for everybody. So what an MSA or master service agreement is this is sort of like a strategic agreement that you enter into. So let's say you're a sub, and let's say you provide transportation hauling services for a street and road contractor, right? You're moving aggregate or dirt or whatever it is you move. And, every time they call you for a couple trucks, you don't want to have to write a contract every time you roll a truck or two for this street and road guy. So what often happens, what they will want to do is they'll say, we're going to enter into this master service agreement with you, the trucking company. And we're going to say at the master agreement level, every time we call you to use you, this sort of this head of terms, they call it, this master agreement is going to apply. And in the master agreement is general things like, who the parties are, general scope of work, although that can be modified based on purchase orders, general insurance provisions, and general indemnity provisions. So no matter what kind of work you do for them in the transportation space, every time you work for them, you're agreeing to adhere to these basic indemnity and insurance provisions. And then what they do to make this operable is every time they need you to roll trucks, they'll send you a purchase order. That purchase order is usually a page or two, right? Talks about dates and times and prices and things. And then it'll refer back to the master agreement and saying, remember we talked about insurance, those insurance provisions apply to this purchase order. So it's like a shorthand way of not having to rewrite a contract every time you do it. They're really popular. We see a lot of that. They're really good for everybody. I mean, as long as you negotiate the master agreement part carefully upstream with your owner, your GC, but they're great tools. They save everybody a lot of time. Did that answer the question? I'm sorry.
I think it did. Let's see if there's any more. I think we're good. I think that concludes our presentation for today. Let me thank our attendees, and especially Kurt Chamberlain with Hub International for an extremely thorough presentation. And